Okay, my topic is psychology of persuasion. The specific topic is, I call it lessons learned from the smart guys. And I'm writing a series of articles about information coming from other sources that can be useful to us as lawyers. I do a lot of cross-training. When storytelling became the big thing, I went out and bought 12 books. Now that sounds like a lot, but you got to understand these books are like so thick. They're just little small books, but they're books about written by screenwriters, people who write for a living, people who write plays for a living, people who write scripts for a living, people who are professional storytellers. So when I wanted to know about storytelling and learn about storytelling and the concept of storytelling, I went to the storytellers to find out how they do it. The same thing is true. I also, on the recommendation of my good friend Russ Herman, he said, you know what I do to learn how to tell a story is I go read the books of Louis L'Amour. Louis L'Amour is the most successful storyteller in history. He's sold, last time I looked, it's 220 million books. And it's all about storytelling. So you go see how does he tell a story, and you get so captured in reading the first one that I literally have I've read all of the Louis L'Amour books now. But cross-training is important to us. Psychologists have a lot to tell us. Forensic psychologists, a whole new field in the last 20 or 30 years, where people who are trained in psychology are now applying their skills to our business, to how jurors react, how jurors act, what motivates jurors, what moves them. So I want to start with the first smart guy, maybe the smartest of them all, was a guy by the name of Aristotle. Aristotle's principles of persuasion. The first, maximize your salient points and minimize your weaknesses. Now, maximizing your salient points doesn't mean asking the same stupid question over and over. It means having a theme. And when you're proving that theme, you come at that theme from every different direction. You come at it with lay witnesses, expert witnesses, documentary evidence, demonstrative evidence, and your pleadings, all the proof that you can have from pleadings. And those things all go together to maximize the salient point by supporting your theme. Then your theme is the central part of your story. And you may have two themes in your story. You may have a damages theme and a causation theme. But that's what's meant by maximize your salient points. Minimize your weaknesses. We all have weaknesses in our case. So you figure out primarily through the use of focus groups is the best way I know to figure it out. But you figure out through the use of focus groups, what are your weaknesses in your case? They'll tell you about weaknesses you had no idea you had in your case. And I've been shocked by weaknesses that focus groups have told me that I have in my cases. But then you minimize your weaknesses. You bring them up early. You bring them up before the defense has an opportunity to, because when you bring them up, you get to put your spin on them. And you only get one chance to make a first impression. You want the first impression of your weaknesses to be your spin, your version of your weaknesses. Plus, the fact that you bring it up means that you're not worried about it. You're not concerned about this weakness. And so just take it head on. Aristotle also said, refresh the memory of your audience frequently. Now, that again comes right back to theming. Refresh from every different direction, every way you can tell the same story, and with refreshing through your documentary evidence, and then come back and support it with expert testimony, support it with lay testimony. But the repetition doesn't mean just repeating the same thing over and over. It means repetition of your theme. It means repetition of the essence of your case, repetition of your causation theme. Now, finally, he said, execute the required level of emotion. Now, this is where we fail most miserably. The word most frequently used to describe jury service is what?
Boring?
Yeah, just like this speech. Boring.
No, not this.
Yeah, okay, I'm demonstrating it for you as I speak. Boring is the word most frequently used by jurors because they come in with this high expectation. that they watch all this fascinating trials on TV. And boy, these trials look like fun. This is going to be a blast. And then they get in there and we absolutely bore them to tears. Now, there's a time for emotion, though, and we have to be very careful. In this age of tort reform, we have to be very careful that we do not use emotion so as to play into the image of the greedy trial lawyer in using emotion. You don't want to use emotion in voir dire examination. You don't want to use it in opening statement. You want to use emotion after the jury is convinced that there's liability in this case, after you've made your liability proof. Usually I save emotion, the true emotional appeal, until the closing portion of the closing argument, at a time when the defense has no opportunity to respond to it. And also that's the concept of recency. That's what the jury remembers when they go into the jury room. So now, Aristotle also said 3 major things: logos, pathos, and ethos. Competence, dynamism, and trustworthiness. Interesting, this was 2,300 years ago. 3 years ago, there was a study done among 1,500 actual jurors in debriefings across the country, 1,500 actual civil trial jurors. And they found, one of the questions they asked was, did you like the lawyer? And then for the 3 people that said they did, they asked them, well, what did you like about your lawyer? What makes people like lawyers? And just like Aristotle said 2,300 years ago, 1, trustworthy, and these are not in any particular order, but trustworthiness, competence, and dynamism. Competence means you don't waste my time. And this is true with judges as well as jurors. You get in there, you don't know the predicates for getting the document into evidence, and you stumble around and you're shuffling around paper, and the judges say, all right, you may proceed. Okay, so well, yeah, and you don't know what you're doing. Competence. They want you to move with competence. You act as if you know what you're doing, and you demonstrate that you know what you're doing. Then dynamism. That means you keep them awake. There's a thing called a trigger or an anchor. You want your anchor to be that when the judge calls your name, something happens. When the judge says, Mr. Dees, you may proceed. When the jury hears, you want this literally to be an anchor. When the jury hears Mr. Dees, they unconsciously, in the unconscious mind, they think, okay, I've got to listen now because something is about to happen. You know how you create that anchor? When your name is called, you make something happen. You don't go in with, now let me see, did I understand that you just testified to this, and then you said this, and then you said this, and the jury's saying, yeah, you stupid ass, I heard it. That's exactly what he just said. We all heard it. You got anything else to add? No, when your name is called, make something happen. Be dynamic. All right, the next thing is education. I added this one because there's absolutely no question we like the people who educate us. When you walk into jury service, you know absolutely nothing about what you're there for. When I first got called to jury duty, I went back and changed after being on. I didn't get to serve, but I went all the way through a voir dire examination. And when I went back and changed the way I did voir dire examination because I had a new perspective. I had a perspective from the viewpoint of the juror. And they call the people that take care of the jurors, in Houston we call them jury shepherds. And the reason they're called jury shepherds is because that's how they treat the jurors. They're like sheep. And when you come over there, you're told where to sit, you're told what to do, you're told to move into this group, now you follow us across the street, now you take this out. They lead you around. All this time, you have no idea if you are there to take a child away from a parent, if you're there to put a drunk driver in jail, if you're there to award one of those multi-million-dollar verdicts that you get every day at the courthouse. They have no idea why you're there because there's such a plethora of things that jurors can do in this country. So when they finally come in, the judge says a few words to them, and that varies according to the judge. But then you stand up on voir dire examination, You're the first person who actually gets the opportunity to educate the jury as to why they're there, what's expected of them, and then you follow through with that on your opening statement. Tell them what their role is and exactly what's going to. You start off. We have the opportunity to begin as the educator, and we like people who enlighten us. So the next issue, trusting the lawyer. The way you gain trust, and this is very important, it's called sequencing. The way we gain trust is how we sequence information. In what order do we put our information now? And what we have to do now is you can't stand up and play into the tort reformers' widely disseminated vision of what a trial lawyer is all about, the greedy trial lawyer. So you want to start, you have to understand, we've done all this work on jury bias. And we're told by jurors and by lots of focus groups, first of all, we know that they don't trust us going in. They don't trust the people representing the plaintiff. They don't trust the plaintiff. That's just the basic fact. The jurors go in suspicious of plaintiffs and suspicious of plaintiffs' lawyers and suspicious of all lawyers for that matter. Remember, it's not just the plaintiff's lawyers they're suspicious of, but they're more suspicious of us because we represent the plaintiffs of whom they're very suspicious. So what you want to do is sequence your proof in such a way that you fortify your words. The part of your case that you come out with early on liability generally is you want to follow it immediately with documentation. You want to follow it with hard evidence, not just your words. You use your words, but then you bring documents, you bring graphs, you bring whatever hard evidence you have in your case to fortify what you've just said, so it's obvious that you're telling the truth. This is not just rhetoric. It's not hyperbole. You're actually supporting what you're saying as you go. And then I always like the military method of teaching, and I use the same thing with a jury. And the military method of teaching is you tell them what you tell them, then you tell them, and then you tell them what you're going to tell them, then you tell them what you told them. That's the military method of teaching. We tell them what our case is about. We tell them what it's going to be. Now, we have to be very, very careful now, since they are suspicious of us. We have to be very careful in that first part of telling them what this case is about, telling them what the evidence will show. You know, we got into the routine before we figured out what we were doing about predicating everything by saying, especially on opening, the evidence will show, the evidence will show, the evidence will show. That's not the way to do it for this reason. How many of you have ever tried a case in which every single thing went on in the case exactly the way you expected it to, and you got absolutely no surprises? If you're going to say anything, you have to say, we hope to hell the evidence will show. Because it's not going to. So whatever you do in this age of suspicion, do not make promises. And when you say to a jury, the evidence will show, they're going to be listening for that evidence. And then that witness changes their mind, or the evidence doesn't go in the way you think, now you've damaged your own trustworthiness. So be careful about making promises. The other thing is avoid overloading. Avoid over-trying your case. Avoid putting on way too much evidence to support the same proposition, because, as you'll see, the overload plays to the disadvantage of the plaintiff. Avoid overreaching or over-trying your case. Here's a simple suggestion for you. Try the case you have, not the case you wish you had. If you got a $200,000 case, try a $200,000 case, not $1 million case. If you've got a case that involves where your client has their injuries, they had injuries, they were injured, they lost time from work, they had medical bills, and now they've recovered, they're back at work, they no longer have the pain and suffering, that's the case you try. You don't go into that case and claim lifetime mental anguish, lifetime physical pain and suffering, because that's exactly how you play into the role model of the greedy trial lawyer. So try the case you have. The next thing, Milton Erickson, the next smart guy. I'm just going to give you one thing from Milton Erickson. Milton Erickson was brilliant. He taught us about consistency and synthesis, synthesizing three things: the verbal communication, and what Tom was just talking to you about, the nonverbal communication and the vocal communication. In the delivery of your message, in the persuasive process, verbal communication is only 8% of the persuasive process. Nonverbal communication, now listen to this. Nonverbal communication is 55% of the persuasive process. Vocal communication is 37% of the persuasive process. And the reason that's so high is because, as much as anything else, the sincerity, your belief in your case, comes from your vocal communication. Do you sound like you believe what you're saying? Do you sound, when you talk about your plaintiff's injuries, do you believe in your plaintiff's injuries? But here's the problem. Since nonverbal communication is 55% of the persuasive process, if you're saying one thing and your nonverbal communication is demonstrating something completely different, what's going to prevail? The nonverbal communication will prevail every time. But what happens then to verbal communication? That means that your verbal communication was not true. So again, you've damaged your trustworthiness, which is absolutely vital. Now remember this applies not only to you, but this synthesis between your verbal, your nonverbal, and your vocal communication applies to every witness you put on the stand. You have to make sure that they're telling the story that they're showing. You have to and you can test them before focus groups. You can videotape them, and you can go back over it with them. I had a guy who was such a terribly, terribly, terribly bad witness, and I put him on videotape, and I would cross-examine him, and then we'd turn off the tape, and I'd say, "Well, here's what happened. Here's what you did," and he said, "I didn't do that." Okay, play the tape. Oh, okay, all right, I didn't. Okay, so now you do it again. He'd do it again. So we did over and over until we got it right, but because this can kill you. So moving on from Milton Erickson, we get to, I'm going to just tell you just this little bit about NLP Communications Model. Quantum energetics is a manipulation of energy in a way that can have measurable results. And here's the important thing about that for us. The measurable results that they've reached is that at any given second, our brain is being pounded with 2 million bits of material, bits of information. Think about that. 2 billion. Now, how can we process 2 billion bits of information? The answer is we can't. So the answer is we don't. So what do we process? We actually process, in a primary representation system, we process by focusing on 143. Now think about that. We process 143 that we select out of 2 million bits of information. And this is per second. Now, deletion of all the rest of that comes through what we start with. The filters that we have in our brains. It's based on our values. We reject things immediately. And this is all done autonomically in the unconscious mind, based upon our values, our beliefs, and our attitude and our biases. So that's why it's so important to learn everything you can about values and beliefs and biases of jurors on juror questionnaires is actually the best way. So let's look at that then. If we're going to focus on that, the representational systems are the auditory system. They're processing information on what they hear, the auditory system. The second is they're processing information, those 145 bits of information on what they see, and they're filtering everything through what they see. But the third thing is really tricky because this is the kinesthetic. The kinesthetic is what they feel. This is what happens when you go into the jury room and you heard the juror discussing it, and he says, I heard Mr. Girardi's closing argument. It was great. It was brilliant. But something about this plaintiff's case just doesn't feel right to me. This is the gut reaction. They can't put their finger on why, but they just didn't agree with Tom. This never happened to Tom, of course, but they can't quite tell you. They can't tell you why, but they just didn't believe what he said. Okay, what is that? That's nonverbal communication in action. They can't put their finger on why they're deciding the way they're deciding, but because they processed it as the nonverbal communication, and they didn't realize they were processing it that way. So these are the things that divide us and that we have to take advantage of. So how we'll talk about how we do this. This is an extremely important principle. It's one of the most important principles we can ever have in a lawsuit. It's called the availability bias. But in quantum energetics, the jury will focus in deliberation where you focus in your evidence. See, this is extremely important to us because we have the opportunity to put this into operation. We get to choose where we focus in the evidence. We get to choose where we focus in the argument. We get to choose focus all the way through, voir dire, opening, and evidence, summation, all the way through. And the idea is we put the focus where we need it on our outcome determinative issues, then the jury will focus on the same thing in the jury room. So that's called the availability principle. Here's an example of how not to use the availability principle. Fernando was very good with his hands, and he loved to work outdoors. What's Fernando's job? Gardener, obviously. No, not really. Fernando, that's not your fault. That's my fault. You see, because the only information I made available to you was that he loves to work with his hands, he loves to work outdoors, he's very good at it. That's my shortcoming, not yours. So if I had changed the information I made available to you very slightly, you could have figured this out pretty easily if you're a baseball fan at all. So in the NPO model, what you focus on increases. So where your thought goes, your energy goes, and what that means is this. We have to think in terms of focusing and what do we want to focus on. And here's one thing to keep in mind when you're talking about focus. The unconscious mind, which is what's referred to now by Daniel Kahneman as the unconscious mind, is the fast thinking in the fast and slow thinking. This is the fast thinking. This is the autonomic response. The unconscious mind does not process negative information. It processes only in the positive. So if you want to communicate with the part of the brain that does the immediate and initial processing of information, we always have to focus on putting things in positive terms. This is why we focus on the choices, and I'll come back to that. We focus on the choices that the defendant has. So we don't say the defendant failed to do this. You say the defendant had these choices available to him, and he chose this one. Always make it a positive choice instead of failure, because saying the defendant did not do that, the defendant failed to, that just simply doesn't resonate in the unconscious mind, which is where your decision making takes place. We always want to focus on fairness. Focus on fairness. The one concept that if you took all the jurors and put them all through focus groups and asked them to describe justice and injustice and all that sort of thing, and what a trial is really all about, and what are you really trying to achieve, the answer is fairness. No one's going to say, no, I don't want a fair verdict. I don't want to deliver a fair verdict. And as far as justice and injustice are concerned, we're not seeking justice, because justice, to say whether this is justice, calls for a philosophical discussion of what is justice. We are trying to correct an injustice. It's all about words. So we try our cases in terms of correcting an injustice and giving the opportunity to the jury to correct an injustice in a case. And so, ladies and gentlemen, who will correct this grave injustice which has been visited upon this plaintiff by the conduct of this defendant? If not you, who? And if not now, when? Injustice. It's all about injustice. You frame your story in positive terms. and focus on defendant's actions. Now, and you focus on the plaintiff's reactions. I'm going to get into that more deeply in just a moment. Now, so this is why we reframe the defendant's actions into positive actions and positive choices. So if you have a medical negligence case, you can argue it in terms of you have your expert testify as to all the options that were available in differential diagnosis at getting to the right point, or the options that were available in surgery, non-surgery, or whatever. But you have your expert testify as to, presented with this set of facts, what were the choices available to this defendant doctor. And then you can start with choice A. If he had chosen A, ladies and gentlemen, which is this, we wouldn't be here, because choice A was this. Here's what would have happened if we had done choice A, and this tragedy would not have occurred. He could have chosen B. And what is B, and what would have happened if he had chosen, how's it done, what would have happened? Instead, he chose C. And C is why we're here today. C is what brought about this tragedy. And so the more choices, and it doesn't matter if medical negligence, if it's the designer of a negligently designed product, if it's a driver, it doesn't matter. The more choices you can show that were available to the defendant that would have avoided this tragic outcome, you get to an exacerbation factor. Not punitive damages, but this is where you exacerbate exacerbate damage recovery. So you want to show you want to have your expert testify to as many choices as possible, and then try to get the defendant to agree that I had this choice and this choice and this choice. That's even better. So it's all about choices. But then when you argue it, it's always in terms of the choices that this person made. I want to switch over to something very important, and this is the main thing I want to talk to you about today, is I want to make sure you understand this distinction, because this is something we can use in virtually every case. Jurors attribute conduct. This is all about causation. It's about attribution for causation. And jurors attribute conduct to either personality of the parties or to situations or circumstances. That's what we know. Now, a very bright guy by the name of Hyder, Professor Hyder, in 1958 said, behavior engulfs the field. And what he was talking about that in the field of interpersonal relationships, what he was talking about was that when it comes to, do you blame, where do you put causation for what occurred here? Do you blame it on the personality? Do you blame it on the circumstances? Do you blame it on the situation? What do you blame it on? He says, he used the words engulfs. It's all about the behavior, which is the conduct of the individual, not the circumstance or the situation. So a guy by the name, and in this he said, people are in the foreground in the deliberative process on causation, and the situation or circumstances are in the background. Now, the way that plays out is Lee Ross, who's a very dear friend of the plaintiff's bar. Lee came and actually spoke. I actually gave this talk in front of Lee Ross, telling everybody what Lee Ross meant when he wrote this. And Lee Ross was sitting in the audience, and that's kind of tricky, but he actually agreed with me, which is nice. And maybe he's just being nice, but Lee Ross is a brilliant guy at Stanford, and he got into this whole attribution thing in our field, attribution of liability. And he came and he explained his attribution. He came up with a fundamental attribution error, and here's the mistake. He says that observers, read the word jurors over-attribute behavior to personality, and jurors under-attribute behavior to situations. Now, that works to our disadvantage, because the behavior they examine is that of the plaintiff, and they've already got a bias against the plaintiff, and they under-attribute situations. And situations are created, for the most part, the situation that causes injury is generally created by the defendant. So when they over-attribute to the personality and under-attribute to the situation, that's disadvantageous to the plaintiff on both ends of it. So let's talk about how we deal with that. The attribution to personality. Attribution to personality. Here's what we have to do. The jurors consider the influence of a party's perceived attitudes, personal traits, and characteristics. So they look very carefully at your plaintiff. So it's extremely important, and this is something that's done unconsciously. This is not something they're sitting there saying, gee, you know, that guy dresses sloppily, he's probably a sloppy driver. That's not how it works. So, but they are attributing this to personal characteristics. Now, the key to this is there are two personalities in the case. There's your driver, and there's, just take the simple shit. You got 18-wheeler hits a car at an intersection. 18-wheeler speeds up, tries to make a red light, hits a car. So you've got also the personality of the 18-wheeler driver. So what you want to stress in your evidence and focus on and, quote, make available, end quote, are the characteristics and traits and attitudes of the driver of the 18-wheeler. And boy, an 18-wheeler drivers, I've done many a deposition of 18-wheeler drivers. Some of the characteristics and traits, watching television, popping pills, all the things they're doing while they're driving, this plays right into the hands. On the other hand, here's what you do on your side. You need to prove, with respect to your plaintiff, not just that the defendant was wrong anymore. I don't think that's enough. You also have to prove that the plaintiff was right. You prove the plaintiff's conduct in some degree of detail to show that as they approached that intersection, they saw the light change to green. They started moving through they just kept going through the intersection because they had a green light. And you prove their conduct as being proper. So let them examine their conduct. And then you prove the defendant's conduct on the other side. So turn the personality who's being scrutinized into the defendant instead of your plaintiff. Now, the attribution to personality, what you want to do, jurors overestimate the effect of plaintiff's personality, so you want to make that the defense. The next thing is attribution to situations. Situation just means the circumstances that they find themselves in. Jurors consider the effects of external forces, situations, and circumstances. But look at the next one, attribution to situations. Jurors underestimate the effect of surrounding circumstances as an influence on causation and damages. So this is what you have to focus on. You have to focus on that the situation was created by the defendant, by the driver. The situation, the decision to try to make it through a red light, the decision to be driving at a high rate of speed, the decision to be driving at a rate of speed that would not allow him to stop in time for the red light. All those things, he created all those circumstances. So you have to point out the circumstances that exist and point out how the circumstances were created by the defendant. I'm not going to go into this. This is a 30-minute speech by itself. But just take my word for it. The experts tell us that information overload makes it more likely that a juror will blame the plaintiff. It's because they start out with a suspicion of the plaintiff, and the more information you give them, the more nuances they can find to find that the plaintiff did something wrong. The plaintiff wants to try a very clean, pristine case. Don't put any extras into it on your plaintiff's conduct. Let them know that your plaintiff did the right thing. Let them know the defendant did the wrong thing. You negate the influence of the personality of the plaintiff on causation and damages, and you focus on the influence of the personality of the defendant on causation and damages. Stress the circumstances created by the defendant, which is what we just talked about. Now, when you do that, you get to this. This is a great attribution concept. Purposive attribution. There are two that go together here. One is called purposive attribution, and the other is called reactive attribution. Purposive attribution plays so very much into our favor, but we have to use it. We have to make it available to the jury. Purposive attribution says that if the jury finds that a party acted on purpose, it's not willful, wanton disregard, but they acted on purpose. What does that mean? They made a choice. To bring it right back down to my favorite theme, they made a choice. If they acted on purpose, then they will tend to, and they caused a tragedy, they will tend to punish that person with a finding of negligence and award of damages. The more they acted on purpose in a negligent way, for example, it's not that the defendant purposely injured the plaintiff, it is that the defendant purposely chose to drive in excess of the speed limit as they're going through a town. The defendant purposely chose to try to, whoops, I'm going to make that red light. I'm going to go ahead and take this red light. He purposely did all the things that created the circumstances. So if you talk about, and you go right back to, it goes right back to, they chose to drive at this rate of speed. He chose going through a town to drive 20 miles in excess of the speed limit. He chose to try to make that red light instead of stopping. He chose to drive at such a speed that he couldn't stop in time for the red light. Those are all choices by the defendant. On the other hand, if he had chosen to drive the speed limit, if he had chosen to put his brakes on when he saw the light changing, if he had chosen to stop on time, this would have never happened. So this is the type of thing where purposive attribution and choice all fit together. Now, here's the good side also for us. Reactive attribution says that if the jury sees that a party is simply reacting to circumstances or reacting to the conduct of the other side, they may even forgive negligence, but they will be very forgiving of that person's conduct. So what's the beauty of that? Is that our plaintiffs are always in the reactive posture. We're reacting to what the defendant does something wrong, the plaintiff reacts to it. So we always posture the defendant as purposive. They made choices. And then we posture the plaintiff as giving the best reaction he could possibly give under the circumstances. The egocentric attribution just means that I would have done this better than you did. That's all. They look at the conduct of someone, the plaintiff, and they say, well, that's not what I would have done. I would have done this better than you. That's all that means. But here's where it gets to be dangerous, and this is a dangerous, dangerous thing for us. It's called defensive attribution. And the reason it's dangerous is because it is counterintuitive. And I'll explain what I mean by that. When you get egocentric attribution combined with hindsight bias is when a jury, they find that when jurors start deliberating on the issue of causation, they start at the end. They start with the collision. They don't start with the conduct of the driver driving up to an intersection. They start at the end, and they work backwards. And they generally work backwards till they get to the first point where they can attribute liability, then they stop. So when you get to hindsight bias and you combine that with egocentric attribution, what you get is this. You get jurors who look at the conduct of the plaintiff and say, I would not have done what the plaintiff did. Therefore, I would not have had this result. Quick example of this, I represented a family over near Beaumont on I-10 when they were building a road off of I-10. And it was a holiday. The contractors, it was a school day, but it was a holiday. The contractors had left. They were not on the scene where they were building. They had taken what used to be the backyards of all these kids, and they turned it into a big old mud hole. And they weren't working that day because there had been rain and water everywhere. So where they were sinking these poles, they turned into 30-foot pits of water. So all the kids in the neighborhood were out playing in the backyard where they always played, except now you got all these mud holes out there. Well, a 5-year-old child falls in to one of them. His 11-year-old brother jumps in to try to save him. The 5-year-old drowns. The 11-year-old has brain injury. The mother was in the home, just like all the other mothers on that block were in the home. When I did focus groups on that case, we were suing the construction company on the basis that they should have put up barriers around those pits. They were all over the place. They should have put up barriers around those to keep those kids away, because everybody knew this was a playground for the kids. When I did the focus groups, the first thing I found was every woman, without exception, did what? Blamed the mother. Blamed the mother. Every man, the men on the focus groups, gave me some really good ideas on what the construction company did wrong. No criticism of construction company. So I did another focus group. We got 24 people in. We got 12 men, 12 women. We presented all the evidence to all of them at one time. Then we separated them into the women together, the men together. All 12 women, without any problem or almost without discussion, blamed the mother. All 12 men sat there and just all they talked about was how bad the construction and all the different things the construction company had done wrong. This is classic defensive attribution, because the women look at that woman and said, look what happened to her. She has a brain damaged child and she has a dead child. That could not happen to me. The defensive attribution, they're defending themselves. This could not happen to me because I would have acted differently. Therefore, what she did was wrong. It was negligent. And the reason this is counterintuitive, if you're standing up here looking at a voir dire panel and you've got a 34-year-old woman with 2 children and one of them is brain injured and the other one is deceased, you look out there and see a 35-year-old woman with 2 children, your intuitive thought is, she will be able to identify with my plaintiff. She's good for me because she will understand the loss. Wrong. The fact is, she will defend herself by saying, I couldn't have lost my children because I wouldn't have done what you did, and she'll blame the whole thing on the plaintiff. So that's the extremely important thing about defensive attribution. And now, the intensity factor. The more serious the damages, the more serious the injury, the more serious the tragedy, the more defensive attribution comes into play, because the more they want to distance themselves from it. Okay, so you want to consider striking jurors who share the most similarities with factors which are causative of the injury to the plaintiff.